Good afternoon, everybody. I'm very happy to welcome you in this workshop of the Moebius project for the new one. Moebius project is a project looking at sovereignty, borders, migration, looking at essentially to the uses of these borders by member states of the European Union, and ethics, the imperative that all the law, international, regional, national human rights protection instruments as ethical, moral principle impose member states to abide by. So we are devoting this workshop in particular to analyze the thickness of borders because of technology. And this is why we decided with Niovi Vavoula to consider in particular the importance of artificial intelligence in the way borders and migration are managed nowadays. Since the few past decades, the performance of EU border controls has significantly transformed through reliance on highly complex digital tools which rely on the collection, the processing, the exploitation of large quantities of personal data of different groups of third country nationals. This is a means to control and to manage the entry and even the return of migrants and failed refugees. The EU borders has become more and more smart. Didier Bigot would say pixelized, others will say shifting, others again will say filtering. This increased digitalization has more recently given way to algorithmization to make sense of the data collected that are numerous, widely numerous, and to identify novel ways to exploit them through the use of artificial intelligence. And this is why we're going to explore today the importance of artificial intelligence in the way of migration and borders are managed nowadays. And I think we have to keep in mind one point that has been highlighted by the Court of Justice of the European Union in the case Ligue des Droits Humains of 2022, insisting on the fact that AI technologies are characterized by their opacity. And we know perfectly that opacity is a way, an open door for some leeways to police, border guards, and military forces to use data for public order, but against human rights protection of migrants that are concerned by the situation. So we are going to analyze all this with four tremendous speakers. I'm thinking of Tamas Molnar first, that will take the floor to present us all the ways that this possibility of algorithmization is going to have on migration management and border control. He is a legal police officer at the European Union Agency for Fundamental Rights, and is also a visiting scholar at Convergences University. Afterwards, we will listen to Evelin Brouwer. She will be very interested in facial recognition and the human rights protection of third country national. She is a senior researcher at the University of Utrecht. Afterwards, we will have the pleasure to listen to Amanda Musco Eklund, who is a PhD student of the Department of Law of the University of Umeå. And finally, we will have some insights from Chris Jones, who is Executive Director of State Watch, and we have a particular insight on European techno borders in the past, in the present, and in the future. We'll take certainly a pause, and afterwards, Niovi Vavoula, who is Associate Professor of Law at the University of Luxembourg, who is well known for working on technologies and borders, will give a discussion of these four papers, and afterwards, the floor will be open to your interventions, to your questions, observations, and so forth. So thank you, everybody, for being here. You are very welcome, and I hope this afternoon will be fascinating for each of you. So let me give the floor to Tamas, who finally appears in flesh and blood on the screen. So the floor is yours for 20-30 minutes. Please, Tamas.
Thanks a lot, Marie-Laure, for giving me the floor. It's my great honor and privilege to be part in this highly topical and timely workshop. Good afternoon, everyone, dear colleagues and participants. Now, again, I'm sharing my So I have a little PPT to share with you. Okay, so share. It's here. It should be working since I just did that 2 minutes ago. Yes, it is here. PPT.
Do not worry, we are going to see your PowerPoint.
Yes,
is it there so we can see it?
Yes, I'm putting it into full screen.
Yeah.
For some reason, the connection is not too stable. Okay, can you see
That's
it? It's
wonderful.
Okay,
perfect.
Full screen. So thanks a lot again. As you can see, my intervention is titled Algorithmic Decision Making in Migration and Security in the EU. So first caveat, I'm not only looking at migration, let's say, scenarios per se, but I will broaden it to cover also internet security. And to what extent such AI-driven decision-making in those areas challenges the right and effective remedy and access to effective legal remedies. So to kick off and to set the scene, I mean, it goes without saying, I mean, everyone knows in this learned audience that discussions have intensified at the EU level in the recent years regarding the use of AI-driven technology by public authorities in the areas of migration, border control, and security more broadly. The Commission is, of course, very active in this regard, including how to use such technologies for Schengen governance. Then the well-known Frontex agency has also been exploring how to further the use of biometric technology in its border management activities. EU LISA, so this EU agency in charge of the operational management of all large-scale UIT systems, has also established a working group in this matter. And it goes without saying that Europol has equally been running projects looking into the various aspects of using trustworthy AI in the internet security domain, including face recognition. So a lot has been going on. And also the so-called large-scale UIT systems ranging from SIS, VIS, Eurodac, and there are the new ones to come like the entry-exit system or ETIAS, the Travel Information Authorization System. All these IT systems at EU level also incorporate some AI element in their functioning. Plus now we have the EU AI Act, which also regulates to some extent the use of AI at the EU level, namely as component of these large-scale UIT systems. So the point is against this contextualization that, I mean, if carefully conceived and implemented and monitored, such use of AI could bring substantial opportunities to improve the efficiency of law enforcement, immigration law enforcement, within the EU while safeguarding and eventually strengthening fundamental rights. So the opportunities are still there. But at the same time, there are also significant risks associated with AI-driven decision making, which include the risk of replacing independent thought and judgment with non-transparent, opaque, automated control, as Marie-Laure has already referred to that. So there are a number of disturbing questions arising out of this context, including on how to ensure effective legal remedies in the case of algorithmic or AI-supported decision-making, how to ensure the right and effective remedy in case an AI-driven decision has negatively affected an individual. So against this backdrop, let's see a brief overview of cross-cutting issues, namely the fundamental rights framework and the key challenges associated with the right to an effective remedy in European law in general. I mean, looking at primary EU law, it's well known that the right to an effective judicial remedy is enshrined in the Charter of Fundamental Rights, Article 47. And also, there's another right which is closely connected to that, the right to good administration, which is also in the Charter. But when it comes to member state action, this is legally binding on member states, not as a charter right, but as a general principle of EU law. Another thing, of course, in this regard, if one claims that these charter rights or these fundamental rights stemming from the EU law apply, is whether the charter applies in a given subject matter. Without going into the details, I submit, and I think there's communist opinion in this regard, that the charter applies in principle in the area of freedom, security, and justice. So it applies in the fields of border management, migration, and also internal security, those areas which are regulated by EU law. And looking at secondary EU law, the EU data protection acquis likewise reconfirms that the right to an effective judicial remedy must be provided in relation to a number of decisions by the data controller, just to use these data protection related terms, and also in relation to the decisions made by the data processor, but also by the supervisory authorities who are actually the data protection authorities at national level. And also looking at all those legal instruments setting up large-scale UIT systems, the constituting instruments also guarantee the rights to remedy to some extent, and this is where problems lie already. Here, as an interim conclusion, I mean, we can state that the right to an effective remedy, of course, covers decisions taken with the support of AI-driven algorithms. This right applies both online and offline, so no matter in which context we examine that. And more concretely, AI used, the AI used for decision-making in our field of migration or internet security more broadly can challenge access to justice in a number of ways. First is that persons concerned are not always aware of the use of AI. They just don't know, especially when their personal data is processed by law enforcement or intelligence agencies in the context of mass surveillance or fighting serious crime. And this is the problem, since the person concerned should be able to know to what extent AI influenced the decision affecting them, and if that's the case, what procedure to follow, including where and how to complain. Then the second thing is what Marie-Laure has just mentioned in her intro, that algorithmic-driven decision-making is notoriously opaque. It's notoriously opaque regarding data collection, algorithm training, selection of data, error rates. So all these issues are just not transparently reported most of the cases. And there's then an ensuing partial explainability or lack of explainability and lack of transparency, the so-called black box effect, which can limit individuals' right to a reasoned decision. And the right to reasoned decision is part and parcel of the right to good administration, but also a fair trial rights. Then a third problem is tied with the limited availability of specialized legal support. What we can see is the lack of expertise and special knowledge amongst lawyers, but also judges, which is a major hindrance in practice when individuals seek access to effective remedies. And the fourth thing just to flag is if there's no access to information about AI in the process, I mean, it's tied to the first one that I mentioned. If the person doesn't know that he or she has been subject to AI-driven data processing or decision-making, then individuals are just not able to defend themselves. So to sum it up, access to effective remedies appears to be much more difficult against decisions supported by AI as compared to other fields of life or other, let's say, kinds of decision making. A number of questions, of course, arise, for instance, against the background of those problems I've just outlined, how to empower the judges, how to empower all lawyers dealing with such cases, then how to avoid the automation bias of the judiciary, since this is just one cross-cutting challenge with using AI. What the machine spits out is taken by humans as you know, unchallengeable outcome. It should be good, it should be accurate, but this is, of course, many times not the case. So how to avoid this automation bias, by judges included, and how to provide the equality of arms between the victims and defendants on the one hand, and the authorities on the other hand, since in this context, definitely the individual is in a much weaker position vis-a-vis the public authorities. And one way, of course, could be like shifting the burden of proof to the law enforcement authority concerned, or at least sharing this onus between the applicant, the individual, and the respondent, the public authority. So against this backdrop, now I would like to go to 3 case studies to highlight some specific problems and issues with access to effective legal remedies. I mean, these 3 case studies are selected from new or emerging fields of big data-driven state action in the area of freedom, security, of justice. And these cases will look more in depth into the challenges individuals face when they want to enforce their right to an effective judicial remedy. The first example, the first case study, is the European Travel Information Authorization System, ETIAS for short, and its screening rules. Just to jump into the middle in the interest of the time, I would like to focus on the screening rules, this algorithm operating and playing a key role in the functioning of ETIAS. The screening rules, actually, this is an algorithm that compares the data provided in a visa-free traveler's online application with specific risk indicators. And these specific risk indicators correspond to identified security, irregular migration, or public health risks. And these risk indicators of these 3 kinds are based on a combination of data on age, range, gender, nationality, place of residence, education, and occupation. So in itself, it's already quite complex. And these screening rules are aimed at assessing a traveler's risks of irregular migration, security, public health. And if the screening rules flag any of them, then this application for visa-free travel, this application for this travel authorization, is sent to a review by human, let's say, staff. So there's this a manual review that we look into more in detail. So now just focusing on the ramifications regarding access to remedy. The first thing is, what does the ETIAS regulation say in this regard? The point of departure is promising, since the regulation expressly guarantees access to remedy for decisions negatively affecting them in case of rejection or withdrawal of an already issued travel authorization. But it's quite a general, let's say, acknowledgement of this right by simply referring back to the system of remedies available under national law. No matter what is available in national law, I mean, given that we are within the force field of EU law, we are acting within the scope of EU law, then the Charter kicks in. So Article 47 on the right and effective remedy guarantees judicial review against such decisions. Then the problem lies in that challenging these decisions might be very difficult in practice. First, of course, the person concerned should be able to know to what extent the output of the screening rules influence the negative decision, like rejecting this travel authorization or revoking an already issued authorization. And then what procedure to follow in such cases. So, of course, then this is the space for national implementing legislation to regulate with care these issues in order to avoid violations of Article 47. Another problem is that it appears that the ETIAS central unit, which is located at Frontex in Warsaw, I mean, it's still the future, but legally the central unit is not obliged to explain the grounds for refusal or to provide individualized information. It can be simply a box-ticking exercise. So the question comes, does that meet the requirement that everyone must be issued with a reasoned decision? And how does this interfere with the rights to a reasoned decision with sufficient detail as part of the right of administration? One recent mitigating measure is worth mentioning. There's a Commission implementing decision which requires the ETIAS national unit, so not the central unit, but the national units in each and every member state, that besides ticking the box, they have to insert a statement of relevant facts and additional reasoning underpinning their decision. So at least this is a good opening. But we still don't know how it will play out in practice, and definitely more needs to be done at national level, at least, to make sure that this right and effective remedy can be actually and meaningfully exercised. So that was just a snapshot. Again, it's incomplete, just to show that in the ETIAS context, this is an issue. And my second example is taken from more the internal security, let's say, field, namely the use of real-time face recognition technology and how to deal with the so-called false positives. I mean, of course, hours could be spent on explaining how face recognition technology works. I mean, it makes it possible to compare individuals' digital facial images to determine whether they are of the same person. It's always comparing, two faces. If it's identification, so-called one-to-many, one captured face is compared to other facial images stored in a database, in a watch list, and so on. And such technologies are currently being tested and piloted and even deployed by member state law enforcement authorities in a number of countries. Here, I would like only to focus on the live real-time facial recognition technology and the problem with the false positives. A false positive is a technical term. A false positive match refers to the situation where an image is falsely matched to another image on the watch list, to simplify things. So someone is identified as bingo, you are a hit, although this is not the person wanted. So this means that the person is wrongly identified as being on the watch list or in the database. And questions of access to effective remedies arise in the event of, for instance, police stops or arrests that have significantly been informed by the outputs produced by a face recognition technology system. And in this context, those affected by police stops or arrests might want to challenge a number of things. First, why their facial image has been included in the watch list, or why it has been done so in a non-transparent way and without their consent. They were not aware of that. In a similar vein, third, they might seek redress for a false positive match that entailed negative consequences for them in case of unlawful stop, search, and arrest, including seeking compensation for any damage suffered. For instance, when someone missed the flight connection or a non-EU national was wrongly prevented from entering the EU, someone missed the business meeting, So negative consequences are manifold. And I mean, in this regard, what we have now in the AI Act, the live real-time face recognition technology is regulated. Most of its use is banned, but this still can be used for law enforcement purposes under strict conditions. And there's a long list of preconditions and authorization and some safeguards. But to my best knowledge and to my best reading, nothing in the AI Act, let's say, expressly governs how to exercise the right on effective remedy in this case. So it's completely under-regulated, and it's a big missing element in my view. Then now I'm turning to the last example, the last case study, which is the use of algorithmic decision-making under the EU Passenger Name Records Directive, the famous or infamous PNR directive. Again, I start with some explanation. I mean, passenger name records, so PNR data, is personal information collected by airlines for commercial or operational purposes when providing air transportation services. And it includes various information. The point is that this info is entered by passengers manually. So they are unverified information, not necessarily accurate. So this declaratory nature of PNR data distinguishes it, for instance, from the so-called advanced passenger information, the API data. And the EU, since 2016, regulates the transfer of such PNR data, both from extra-EU flights, which is a compulsory thing, it's an obligation, it's a shall clause, and also intra-EU flights, which is a possibility, it's a may clause, by air carriers, and then this information pushed by air carriers to law enforcement authorities are then processed for the purposes of, preventing, detecting, so fighting serious crime and terrorist offenses. When it comes to the processing, every member state had to establish a so-called Passenger Information Unit, the PIU, which is part of their law enforcement structure. And this PIU is responsible for collecting and storing and processing the PNR data gathered from the airlines, and also to transfer such data to the competent national authorities for further processing and checking in databases. And when processing such data for the above-mentioned two purposes, combating serious crime and terrorism, then this must remain within the confines of three specific actions. The first is a pre-arrival assessment of passengers, all the passengers, against predetermined risk criteria. And this exercise is powered by AI. It's carried out by algorithms, this pre-arrival assessment against predetermined risk criteria. And then it's also assessed against relevant law enforcement databases, both at national and EU level. The second action is carrying out specific investigations and prosecutions if there's a hit, and they can move on with the concrete hit. And also there's a feedback element. The data is also used as input in the development or updating of the risk assessment criteria as well. So then again here, the problem is that the use of these predetermined criteria by algorithms and spitting out results, spitting out hits, can lead to many false positives. Even if in terms of percentage, it can be 0.001 out of millions of people. I mean, still thousands or 10,000s of people are wrongly flagged and are subjected to further police action. So, of course, against any unlawful arrest or stop or police action, then the people concerned may want to seek remedy. The PNR directive itself, however, does not mention the right to appeal or judicial remedy in general. So it's completely silent on that front. Only the rights to judicial redress as part of the more specific data subject rights in application of the data protection acquis of the EU features therein. So it's very, very, let's say, narrow. Nevertheless, I mean, again, taking the Charter, Article 47 and the right on effective remedy against all kinds of decision-making concerning PNR processing is there. So the Charter kicks in. Member states are acting even in the scope of EU law. This goes without saying. So the judicial review of such measures must be accessible at national level. Yet effectively challenging PNR-related police actions can be extremely cumbersome. Just let me give you 3 examples, and I'm soon close my intervention. The first one is very similar, I have already described with regard to ETIAS, notably that the person concerned should be able to know to what extent the output of the algorithm, the output used for processing PNR data, influence the measure taken against them. So currently, it's still not the case. And at least the EU Court of Justice has recently shed some light on the legal permissibility of using certain forms of algorithms or AI for PNR purposes, also from the vantage point of exercising this right on effective remedy. And that was the Ligue des droits humains case, where the EU court underscored that the opacity which characterizes the way in which AI technology works might make it impossible, it's a bit soft, might make it impossible, to understand the reason why a given program arrived at a positive match, then depriving the passengers of their right on effective judicial remedy. So the court clearly stated that there's an issue with that. So far, this is the end of the story. I mean, there's this judicial pronouncement, but it's still unclear in the individual case how the person would be able then to access to justice, and whether, we still don't know, whether member states actually use such algorithms like machine learning, self-learning algorithms, which remain so opaque and black box that it's just impossible to understand how they reach a conclusion. And then another thing stemming from the EU court's ruling is it appears that this case sets out even notification requirements in case of positive matches, which is again an opening for injecting more clarity and to inform the person concerned so that he or she is able to exercise their rights to access judicial redress. I mean, notwithstanding all this and some positive elements of the Ligue des droits humains ruling, a more general question arises. One might ask, do effective remedies actually exist against the very high number of built-in non-rights compliant outcomes of such data mining and mass profiling? I mean, PNR data processing concerns everyone. I think every one of us has already, traveled by air. Our data has also been processed as PNR data. And I mean, because of this mass profiling, mass data mining, so many wrongful outcomes can come up that even in questions whether a judicial system is up to, providing effective remedy if all the people theoretically would go against the negative decisions affecting them. So now I would like to conclude in 2 sentences. I believe that these 3 case studies of ETIAS, live face recognition technologies, and the EU PNR system demonstrated that AI technologies can considerably alter the nature of the decisions that affected individuals that they might want to contest. So the crux of the matter is that effective legal remedies must rely on transparency, explainability, and sufficiently reasoned decision-making. And each of the 3 AI use cases demonstrated significant gaps, unanswered questions, and gray zones in this regard. So such algorithm and AI tools seem to be too opaque to allow for effective judicial remedy against their recommendations, against their output in general, as it is often impossible to understand from the outside how they work. I mean, to close on a positive note or a hope, on a point of hope, I mean, the AI Act with all the shortcomings and missing elements may bring some more clarity in this regard, especially when it gets operationalized, it gets rolled out, and it gets applied at national level. If courts are empowered and judges are likewise empowered and have the necessary expertise, it can be, let's say, lead us towards a more genuine exercise of this right, and can bring more opportunities for affected persons seeking remedy against AI-driven decision-making affecting them. So that was just a quick expose. I leave it here. Thanks a lot for the kind attention, and I'm very much looking forward to the other presentations and the ensuing discussion, and of course Niovi's insightful comments. Over to you, Marie-Laure. I stop sharing, and voila.
On t'entend pas, Marie-Laure.
You can't hear me.
Now I can hear you.
Okay, so I can talk. I was just saying that this introduction was very good in order to highlight how deep and how wide the black boxes of this decision, this algorithmic decision, are made, and how deep and wide the violations of human rights of migrants, but also of nationals, can be. And I think that we have to think of these threats to security, legal migration law, public health, and how these are defined under criteria that can make an algorithm consider we have a hit. So here we have some questions that must be embraced, that can be very, very disturbing. For instance, is nationality something that is considered as an element to assess the possible threat of irregular migration, and therefore a hit in order to refuse an HS possibility? So I'm going to stop here, and I'm going to give the floor to Evelin to dive into the question of this right to privacy, and how all these instruments, and in particular the facial recognition technology, can affect, can violate, can infringe the right of privacy that is recognized by the Charter of Fundamental Rights of the European Union and also the Convention of European Rights. Thank you so much, Evelin. The floor is yours.
Thank you so much, Marie-Laure, inviting us and bringing us together. It's a pleasure, and I think we can learn so much this afternoon from each other. And I especially hope to be able to do so, because I'm in a new topic for myself. In the sense, I'm really grateful for the presentation of Thomas on legal remedies and large-scale databases, and I'm looking forward to also to the presentation of Amanda and Chris Jones, because I think it's really complementary, and we are all concerned about the level of protection of fundamental rights, human rights. And one disclaimer, I focus in my contribution now on Article 8 ECHR, the right to private life, not saying that the Charter, GDPR, law enforcement directive are not relevant. I do believe they may be even more relevant than Article 8 ECHR, but I have a purpose because it is connected with the topic, which is the possible use, the not yet use of real-time and post-facial recognition on a remote basis at the borders. while using data in large-scale databases. And I want to take you with me through this journey, whether this is a realistic future ahead of us, and I'm also looking forward to the presentation of Chris Jones. And I will connect that with the protection of the AI Act. So I will first address some examples, possibly incentives, for using remote facial recognition at the borders for surveillance purposes. Also pointing out to existing national and European Union projects within this field, and then pointing out to specific principles on the right to private life, protecting individuals against this mass surveillance, possible surveillance at the borders, and then going to the AI Act. What brings the AI Act in this picture? And Marie-Laure, I'm very grateful that you just pointed before introducing me to the fact that this concerns the specific position of non-EU nationals. Are non-nationals or non-EU nationals maybe easier a target for these fundamental rights agencies, fundamental rights violations? Because this is a concern which always triggers me in my work, and which also is relevant with, as Thomas said, the importance of access to legal remedies and to be treated in the same way concerning data protection principles. But now I'm focusing on Article 8, ECHR, right to private life. And why is my concern based on current developments? Well, first of all, because we have a field, and many of the attendants, including Niovi, and I'm very looking forward to your comments, know that there's a massive, a large collection, storage, long-term storage of personal data on third country nationals only in those 6 large-scale databases, large-scale information bases: Eurodac, Schengen Information System, Visa Information System, and in future, near future, Entry-Exit System, ETIAS, which was already mentioned, and ECRIS, third country nationals. I come back to ECRIS if I have time. This is a criminal record system, but only including data on third country nationals. What I also have to emphasize or underline is those databases include central storage of biometrics, including photographs and facial images, but also fingerprints, of course, on third country nationals, currently used for the purpose of identification, verification, or in the case of the Schengen Information System or Eurodac, to find a hit. Has this person been reported by another state for any of the purposes of Eurodac or Schengen Information System? What I also want to emphasize that all those databases, some gradually over time changing the basic legislation, some like ETIAS immediately from the start included in the specific legislation, they are allowed for access for law enforcement purposes. And I have to say under conditions, but either way, the EU legislator found the data storage, even if meant for border control or asylum migration purposes, found it feasible to make sure that in case this would be necessary in a prosecution, criminal investigation, to make it accessible for law enforcement purpose, which also includes the use by Europol and sometimes Eurojust. Well, I really wonder about your thoughts, because maybe I'm missing something, but first inventarization shows me there's no basis for this remote facial recognition use. So I really mean that from either using video coverage or possibly drones or cameras at the internal or external borders, that facial images in the databases can be real-time compared with people entering the Schengen zone or the European zone, or even in the internal territory. But you see, first, in the existing law, very much an emphasis on future or existing use of new technologies. Like in Eurodac regulation, EU LISA will add in 2027 use of facial recognition software. The Schengen Information System regulation provides that the Commission will adopt delegated acts on the determination of other circumstances in which photographs and facial images may be used to identify persons. But to be honest, this can be everything. This can be in other circumstances. So Article 33 is about controls in remote areas of borders. For checking, can this person enter the Schengen area? But other circumstances can be everything. That can be also for law enforcement purposes, but also doing it differently, for example, than by border guards being at the border post, checking people with facial images, which is now provided in the laws and in the Schengen Borders Code. So this triggers me, but I wonder if I'm reading too much in it, and I really love to discuss that. And in the screening regulation, there's also provision that large-scale databases, so the 6 ones I mentioned, including photographs and facial images, can be used to identify or verify identity of persons at external borders and within the territory. And this is also very important. We are only, if you're talking about border management, the borders are coming inside. Didier Bigot, I'm happy to see you also here in the audience, and Elspeth Kaalt pointed already out the Schengen borders are everywhere. Well, with technology, the borders are really everywhere. And therefore, in this new screening regulation, which is a part of the new Asylum and Migration Pact, technologies are immediately extended, provided to be used within the borders, which may raise some concern. Then Schengen Borders Code is about how control at the borders, but for surveillance purposes, which is also important to emphasize. So surveillance which include law enforcement purposes, can be based at the borders by mobile units, by stationary units, and in addition, surveillance may also be carried out by technical means, including electronic means, and so on and so on. I maybe don't have to mention now all the examples, but it's really important, I think, that as lawyers we are also aware and we should follow the future acts, like, for example, based on the Schengen Borders Act, the Commission power to adopt delegated acts. I haven't seen the implementation of this on 35 from the Schengen Borders Code, that is delegated act for measures governing surveillance, which can also include everything. But I think this is really, we as lawyers, but also FRA and NGOs addressing this point, should be really following and considering the content of those measures. And also in the Frontex regulation, but it's also not new for most of the attendants of this meeting, provides several provisions emphasizing the current or future use of new technologies. And from these angles in existing legislation, going to the already current pilot projects, both at the EU level and the national level, I do really think that there is a strong incentive of using, and of course, as we know, with the political background, but also with the pressure of big industries and the feasibility of industries to sell their sophisticated new technologies to specifically EU agencies, but also national member states. I do think there is a possibility or a sort of strong incentive to use facial recognition on a remote, either real life or remote, at the borders or in border areas or even within the territories. And well, I mentioned Roborder, Andromeda, Arecibo, and the new PopEye. These are all EU-funded research projects. They're not all including or really pointing out investigating facial recognition technologies, but there are some angles also because of the opacity of the goal of those projects. We had already the eye border control, which many also amongst you have written about, the opacity, the lack of transparency of the outcome of these horizon EU-funded projects. That this concerned lie detectors or polygraphs. But also here we should aware, well, what are those companies supporting new EU policies developing? What are the tools they are developing, and what kind of pilots are now taking place? And it's also important, and it's also very informative to go to each website of the EU agencies, EU LISA, Frontex. Frontex has every year or every 2 years an industry day, so even an organized industry day where the industry companies can bring their tools, instruments to the fore, and Europol to see where the new policies might be going into the future. And also at the national level, and there are many projects or even existing measures of facial recognition, mostly for law enforcement purposes, as we know in the UK and the police in London, the city police, but also in Hungary, also at borders, also at airports and cities. And the wonderful, but already some older report of the Fundamental Rights Agency provides some examples. State Watch, of course, is very active on following these pilots or existing laws, but I also want to refer to existing research by Marie-Laure and Saline Route. I don't say the name right, but Musco, Moulin, and as I said, State Watch. But I'm grateful for having so many amongst you following these developments, but it's also my wish that we keep on doing so. Now, going to Article 8 ECHR, and this is a bit basic, going back to the basics, the principles of Article 8, the right to private life, which is, of course, an opaque, very flexible individual right against the government, but I think also important, it is really important, right, basic protection against misuse, against disbalanced use of powers by the state, and specifically in surveillance situations. And of course, the classic judgment has been Class versus Oldesfurter Germany, which was about telecommunications, so old-fashioned surveillance tools, communication. So we're not at all about facial recognition. But I think going back, it is important that we can see that the Court of Human Rights, which in that case even didn't find a violation. It was about the German security powers, internal security powers, didn't find a violation. But it is important because of at least 2 issues that the review, and also Thomas, you pointed out with legal remedies, but connected to the purpose of the AI Act, I think it's also important that this review should be at 3 stages, as has been pointed out already in 1978 by the Court of Human Rights. So when it is ordered, apologies, when it is ordered, when it's developed, also when it's carried out, but also when it has been terminated. So access to legal remedies, which has also been specifically pointed out, where abuse is potentially so easy in individual cases, and large-scale surveillance using facial recognition on a real-time basis is potentially risking to violate human rights. Control to a judge is desirable. Well, desirable is not so strong. I really developed now to you should have effective remedies, but I think it's an important message which should be also always been put on the forefront when dealing with new technologies. 55 years later, we have the famous Lukin case against Russia, which is one of the first cases on facial recognition technologies and in real life, while Moscow police was using video footage to detect and identify a person who was a demonstrator, and he was found, not only identified, but also found and arrested in the Moscow underground. Well, the court found a violation, also pointing out two important criteria and safeguards. And I think it's also important that the court not only referred to the Council of Europe owns guidelines, but also to existing EU law. So again, in this story, the basis of EU law and the GDPR and the Charter remains important, but the court also pointed this out and pointed out the responsibility of governments using new technologies and the careful balancing when using those technologies for the purpose of criminal justice. Again, like in earlier judgments, for example, Marker versus UK, pointing out to the chilling effect when surveillance has been used. As I said, founding a violation because he was identified and arrested while traveling. And important, the court didn't impose a ban on facial recognition for law enforcement or on real life facial recognition. And the case was very much connected to the case. It was a person also expressing his thoughts, freedom of expression, freedom of assembly. But the court said, well, this needs a prior assessment. There needs a high level of justification introducing these technologies and the need of procedural safeguards, supervisory control mechanisms, and legal remedies. And of course, again and again and again, this all has to be read in combination with maybe much further development of the case of the Court of Justice, pointing out a much clearer definition of strict necessity test. Catherine Jasron just recently had a brilliant contribution on that topic in connection with remote facial recognition. I also want to point out to an earlier judgment, but also quite recently, which was about the indefinite storage of personal data, again, here in this case by the UK, pointing out to the proportionality, which should also be measured in connection with future use. So here, the case was not about remote or real-life facial recognition, but the court here measured already the proportionality of the storage and collection of personal data towards the possibility of new technologies. And this is also something which I think is important when dealing with this topic. Well, the AI Act, and I don't know how much time I have. In a nutshell, the information is on this slide, but I can give some more information in the next slides. Marie-Laure, how many minutes?
10 minutes if you want.
Oh, okay, that I manage. Well, now the AI Act, what brings it to us? Many of us, of you, other speakers, attendants have written about the scope of the AI Act, also within the field of border and asylum management and the use of AI. With regard to remote biometric identification, which includes remote facial recognition technologies, I found it a bit puzzling, and I also like to discuss this afternoon or maybe in future with you. Generally, and I should also emphasize that other recitals very much emphasize the purpose of the AI Act is to protect fundamental rights against intrusive use of AI, against the black box Thomas already referred to. So the goal of the AI Act is clear, is to protect fundamental rights in the context of those new technologies. Because to be fair, we don't know what AI will bring us in future. It's really a running target as we speak here this afternoon. And also with regard to remote biometric identification, it seems really to recognize that it may affect the privacy life of a large part of the population, evoking a feeling of constant surveillance, indirectly dissuade the exercise of the freedom of assembly and other fundamental rights. Here I would like to stress other fundamental rights connected with third country nationals. We should consider especially the rights of asylum seekers, the rights of people seeking family life, but also the right to effective remedies for third country nationals being refused at the borders. And the private life of third country nationals, which is a general data protection right. So the purpose is clear, but what does it bring us if facial recognition would be used at the borders in the way I described for third country nationals? Well, in my view, I see 4 possibilities where remote biometric identification in connection with the use of the data in a large-scale databases can be part of. First, the general prohibition of law enforcement use of remote biometric identification without any exception, and I'll come back to that in a moment. Then, under the prohibition, so again in Article 5, of AI systems, but with exceptions, or a high-risk system with specific safeguards, which also includes the remote biometric identification for law enforcement purpose, or generally, and this is a category in Annex 3 on the high-risk systems, that it's just one of the remote biometric tools which can be allowed under the conditions in the AI Act of the high-risk systems. Well, this may be a bit puzzling, but I hope to be clear. The first, in the next slides, the first possibility option is this absolute ban on systems that create or expand facial recognition databases through the untargeted scraping of facial images from the internet or CCTV footage or video footage. Well, this sounds reassuring because this means that large-scale databases cannot be expanded by using the data with, for example, video footage at the borders. But somehow I'm not so assured that this is really excluding this future use. So I would like to discuss that with you because it seems really focused on this untargeted scraping and sort of untargeted use of data and then going through, like for example, at the street, the football place to check individuals. But if this is the basis to prohibit the facial recognition tools in connection with the large-scale databases, then my contribution ends because then the case is solved. But as I mentioned before, large-scale databases can be used for law enforcement purposes. And interestingly, the AI Act and many others already has written about it and about the problematic revelation in the AI Act, that yes, the AI Act prohibits remote biometric identification in public spaces for the purpose of law enforcement, but with exceptions. And these have been added later. The European Parliament first was in favor of complete ban. And that is in target search for specific victims of really serious crimes, but also to find missing persons, trafficking in human beings, preventing threats to life, so in the event of terrorist attacks, and that could be important, again, to our topic, localization, identification of persons, who are suspected or having committed the criminal acts included in Annex 2 of the AI Act. This includes one of the crimes, and that are the more serious crimes, and we can understand that police, internal agencies want to have a tool like an immediate event of a serious crime to find the person suspected or having committed that crime. But this includes human trafficking. Human trafficking is really a sort of open goal, in my view, because human trafficking is so much on the forefront of European policymakers when dealing with migration and asylum policies. So here, I'm a bit afraid that this could be the justification. Oh, we need the large-scale databases and we need the facial recognition tools to find suspected persons or convicted persons on human trafficking. And there are some safeguards and important safeguards, again, judicial or independent administrative authorities, prior authorizing such use of such tools, which is certainly important. Well, then the AI Act adds another remote biometric identification tools, but not prior, but post, after making the images in public spaces. And they are not explicitly developed as a high risk, but Article 26.10, you can find, oh, they are allowed, and they fall under the general conditions of high-risk systems, plus the conditions included in Article 26, under 10. So again, a prior authorization, but not in 24 hours, but 48 hours or prior. And also the connection with really law enforcement purposes, but they are prohibited if there is an untargeted use of that tool. And importantly, member states may introduce more restrictive laws. So here also the post facial recognition tools and using the data from large-scale databases may be allowed. And then finally, Annex 3 defines as a high-risk system, in general, the use of biometrics, as long as it is used under EU law or relevant national law, including remote biometric identification system, not including AI systems for what I call one-to-one verification to see, are you the person you are to be, for example, at the door or for enterprises. And here, I wonder how this will be used and how future plans for remote biometric identification in migration border policies will use this part for a legal basis. And here also I want to point out two relevant literature, and especially with the unclear rules on the remote, the post and the prior remote biometric identification. Jenani and Tas has written an excellent blog on that, but also the further use and use of large-scale databases for facial recognition. Stuart, Fink, Musco, Eklund, I'm happy to hear you in a moment, and Mobilio, and of course, Niovi, Vavoula. To conclude, so currently they are not so used, but you can really identify a strong incentive for future use of remote real-time and post-facial recognition at the borders, both for law enforcement purpose and possibly also just to detect irregular or to be returned migrants. Article 80 CHR doesn't provide a ban on facial recognition on law enforcement context. The European Court of Human Rights is quite willing to, or not willing, but allows facial recognition under conditions as long as there's really a balance on the need to use that tool, and it's a really pressing need to use that tool. Comparable with the strictly necessity test of the Court of Justice based on the GDPR in Article 7 and 8 of the Charter. But when you consider the case the Court of Human Rights already dealt with, you can derive the fact, well, if you're using data for this facial recognition systems, which mostly include data on innocent third country nationals who are forced to provide their data because they apply for a visa or enter EU or are for any other reason in one of the databases. I think that the strictly necessity test or the test of the 8 ECHR in any case will fall in favor of third country national or in favor of a prohibition of such use. And going to the AI Act, for this moment, my analysis that is really an unclear, differentiated framework, which doesn't help us to understand or to provide guidelines how to deal with the tools in future because of this categorization. But also, even if you can agree, well, if we know under which framework facial recognition tools, as we talk about, fall within, in which category it falls within the AI, there are sufficient safeguards, they are important, but then the very important question remains, well, who will be starting controlling the confirmation to those safeguards, also because many actors are involved. We are talking about the developers. AI wants the industry already taking care of the human rights impact or the impact of tools being developed, and of course also the deployers, the users, and the post users in any case. So I think yes, it's important to work further, but it's also running. It's in development which goes on, and I really hope to find further answers in my contribution when I finish it, but also with help of your comments and the discussion this afternoon. Thank you very much.
Thank you so much, dear. It was very fascinating and it was quite concerning too, because all this facial recognition technology, these remote biometric identification systems seem to open the floor to give some leeway for law enforcement officers to do what they want, to gather information as many as they want without any restriction, and the law seems so thin, so shy, so feeble that it's difficult to imagine how far she can go in order to protect our right to privacy under Article 7 of the European Convention of Human Rights and Article 8 of the Charter of Fundamental Rights. And I think that here we have some issues to underscore. First of all these technologies do not seem to me to have been human rights by design thinking. So we have to look at it further. And I think that we could refer to the huge project Didier Bigot was part of, guarding who guards the guardians. So it's all for our security, they said, but is that so? And third of all, what is the job of our judges looking at the appropriateness, the necessity and the proportionality of this use of all these technologies? I'm thinking of France today with all the strikes and the demonstrations and the deployment of all these drones all over the country. So what is this appropriateness, necessity and proportionality? But I'm going to stop there. Many comments to make, and just want to give the floor to Amanda, and she will talk to us about the forcibility, another very important point that could be useful to highlight and to deconstruct in order to understand how important it is. Dear Amanda, the floor is yours.
Thank you very much. Do you see my PowerPoint well? It's
we
just
can see it perfectly. Perfectly.
You see a turtle. Great.
Yes.
Yeah, we can see it.
First of all, thank you for inviting me here today. Now, maybe some of you are familiar with different illustrations of turtles with sail on its back. And for you who aren't, it symbolizes the motto Festina Lente, which basically means hurry up, but do it slowly. Now, remember this turtle because we will go back to that in the end of my presentation. I will speak about the automation of EU border control and its rule of law implications. More specifically, I will focus on automated risk assessments and the rule of law requirement that laws must be sufficiently foreseeable to prevent arbitrariness. The presentation is based on a longer draft article I'm about to submit, where I study the foreseeability requirement as a component of the rule of law principle of legality, which serves as the initial criterion for assessing the lawfulness of interferences with fundamental rights. My conclusions are drawn based on analyzing mainly the Court of Justice, but also the European Court of Human Rights interpretation of the foreseeability requirement in 3 domains: electronic surveillance, automation, and border control. As you can say, automated border control is at the intersection of all these contexts. I've selected 3 tentative main points from this work in progress that I will share with you today, and they all revolve around my growing concern on whether the foreseeability requirement continues to fulfill its function in EU law to constrain public power and prevent arbitrariness in the face of increasing automation. But first, I will introduce myself. My name is Musco Eklund. I originally come from a professional maritime background and most recently worked for Doctors Without Borders in the Mediterranean as a search and rescue boat driver. This experience made me change career path from maritime basically, to law, with the aim to use the law to confront issues I witnessed. And I've been fortunate to have the chance to be involved in practical litigation in pushback cases before the Court of Justice. A large interest of mine is also questions on automation, which comes from when I worked at the Swedish Defense Research Agency analyzing autonomous weapon systems. And now I'm at the end phase of writing my PhD thesis on the automation of EU border control and its rule of law implications. And I do this at Umeå University, up in the forests of North Sweden. Turning first to the technology at the center of my analysis, this will a bit echo what Tamas already discussed, but this will be a bit of a repetition. It's automated risk assessments in EU border control that is the center. Traditional risk assessments at border crossing points or in visa procedures are increasingly being complemented by automated risk assessments taking place before arriving at the border. And automated risk assessments usually involves the use of a screening algorithm, which will compare on one hand predetermined risk criteria with, on the other hand, personal data in order to identify correlations between these two. And any hits would then be subject to manual processing by a human. Now, the ETIAS and the revised VIS regulations establish such automated risk assessments as a part of the EU's own IT systems, ETIAS, for visa-exempt third country nationals, and the VIS for third country nationals applying for a visa, with the purpose to assess if the applicant poses security, illegal immigration, or high epidemic risk. And as these are EU IT systems, predetermined criteria are established by EU agency Frontex on the basis of non-legislative acts adopted by the Commission and algorithms established by the EU agency EU-LISA. While not an EU IT system, the PNR directive similarly established automated risk assessments, but for the analysis of passenger name record data, PNR data, of air travelers to identify persons who may be involved in a terrorist offense or serious crime. And there, instead of EU actors, the national authorities of the member states establish the predetermined criteria. Moving on from automated risk assessments, I'll briefly introduce the foreseeability requirement, which is the lens through which I study this technology. Fundamental rights and rule of law problems related to automation are often discussed as problems of necessity and proportionality. However, I also find fundamental issues in the step before, which is compliance with the basic principle of legality. Now, the principle of legality is in essence a limited exercise of public power, with first a formal aspect that there is some basis in law, but also a substantive aspect on the quality of laws in order to ensure that powers are sufficiently defined so that its exercise is foreseeable to the individual and not arbitrary. According to Article 52(1) of the Charter, any limitations to rights must be provided for by law, which is an expression for that the principle of legality contains a substantive quality of law assessment similar to that of the European Court of Human Rights when assessing the in accordance with the law condition for limitations in the rights to privacy in Article 8 of the Convention. The rights perhaps foremostly interfere with when indiscriminate risk assessments based on personal data is introduced in the EU border regime are the rights to privacy and data protection of Articles 7 and 8 of the Charter. And the Court of Justice interpretation of the foreseeability requirement has concrete implications for the effective protection of these rights, since the foreseeability requirement is of key importance to prevent limitations in these rights, and it is even metaphorically the actual key to unlock lawful limitations to charter rights. Looking closer at Article 52(1) of the Charter, it refers to two principles: legality in the first sentence with the provided for by law requirement, and proportionality in the second. Now, according to the Court of Justice, the provided for by law condition implies that the act which permits the interference with those rights must itself define the scope of the limitation on the exercise of the right concerned. However, the Court of Justice case law often shifts focus from the provided for by law condition to the question whether legislation is clear and precise, which, even if it's clearly connected to foreseeability, as clarity and precision in law provides for foreseeability, is actually a part of the Court of Justice proportionality assessment. This takes me to the first point, where I will discuss some rule of law risks with assessing legality jointly with proportionality. Even if foreseeability is an element of the principle of legality, in case law where security and surveillance is concerned, both the Court of Justice and the European Court of Human Rights in practice often assess foreseeability either in conjunction with or as a part of the assessment of necessity and proportionality. And this slightly deviates from the typical method of assessing interferences by assessing first if there exists a formal legal basis to the interference and if this law lives up to quality of law requirements on foreseeability and accessibility. And secondly, only if this condition is fulfilled, moving on to matters of the legitimate aim of measures, their necessity and proportionality. On one hand, in case law concerning surveillance measures, that interference with privacy and data protection, both the Court of Justice and the European Court of Human Rights consistently highlight the inherent risk of abuse, that this calls for strict necessity and particularly specific rules. But on the other hand, both courts also stress that too much foreseeability may undermine the effectiveness of such measures and harm the very objective of a regime. And these conflicting concerns creates a dilemma regarding the foreseeability requirement in these surveillance contexts. Therefore, one could say that ensuring foreseeability is particularly challenging in regulatory contexts where full transparency conflicts with the legislative objectives and where flexibility of law is essential to respond to the evolving circumstances. The context of automated risk assessments in border control resembles that of secret surveillance in that the pressing general interests must be weighed against relatively minor interferences into privacy and data protection. And I see reason to be cautious with assessing foreseeability and proportionality jointly, as it is likely to determine of a high level of foreseeability as the public interests are pressing and may downplay the relatively minor interferences in the rights to privacy and data protection. A key concern is that neither courts consistently explains why these assessments are conducted jointly or separately in specific cases, leaving the underlying reason unclear. Moreover, when a violation is found, it's not always evident whether it stems from the unforeseeable legislation, indicating a lack of foreseeability and therefore quality of law, or from the interference being disproportional. And this ambiguity raises a fundamental question about the purpose of the foreseeability requirement. Is the function of ensuring foreseeable exercise of power truly dependent on the necessity of the interference? Because the way I see it, these are distinct legal standards with separate functions, and mixing them might have negative rule of law implications. Legality operates at the legislative level, providing quality of law and limiting discretion, while necessity and proportionality relate to the justification of an interference. Considering that both the Court of Justice and the European Court of Human Rights often assess the quality of law within the proportionality assessment, and since the assessment of the clarity and precision of law is defined by the Court of Justice as a part of the proportionality assessment, this raises the question also of what role remains for the provided for by law condition beyond ensuring the existence of a formal legal basis, especially assuming that the EU legislator acts rationally and that legal provisions should not overlap each other to the point of redundancy. I argue that if legislation regulating automated risk assessments with unforeseeable legal effects is approved by the Court of Justice on the basis of a necessity and proportionality assessment which sidelines the actual foreseeability of law in the name of pressing general interests, the foreseeability requirement loses its function as a gatekeeper to prevent at an early stage limitations which fails to fulfill the basic rule of law standards on the quality of law. Moving on to my second point today, I want to discuss how automated risk assessments challenges the concept of reasonable suspicion. The concept of reasonable suspicion requires a level of objective suspicion, such as factual indications that a person is planning, committing, or has committed relevant acts. The requirement of reasonable suspicion is also closely linked to the foreseeability requirement, because if legislation does not require authorities to demonstrate reasonable suspicion before interfering with individual rights, it becomes less foreseeable when and how such interferences will occur. In the context of automated risk assessments under the PNR, the VIS, and the ETIAS regimes, the first interference with privacy and data protection arises from the general and indiscriminate processing of personal data. This is not based on individual behavior or reasonable suspicion, but rather on status, such as being a passenger under the PNR directive or a third country national seeking entry to the EU under the ETIAS and VIS. But beyond this first interference, I argue a second interference, and perhaps the most crucial one, occurs when an individual is flagged as a hit in the automated screening process. These individuals are filtered out as potentially risky, and following manual review may be subjected to further measures or finally denied entry, travel authorization, or visa. And according to the Court of Justice, the criteria used in such advanced assessments must be determined in a way that they target specifically individuals who might be reasonably suspected. However, the main point of automated risk assessments is to profile personal data in order to detect patterns not necessarily linked to known or suspected criminal behavior. If reasonable suspicion based on such behavior existed, traditional database cross-checks would often suffice. Instead, these systems aim to identify individuals who might be subject to reasonable suspicion, which is not the same as actually being subjected to reasonable suspicion. And this approach is similar to that of predictive policing. and reflects a shift toward using technology to detect potential threats before they manifest in ways that would meet the legal threshold for reasonable suspicion. And the trigger for this second interference is not based on a causal link between an individual and a specific risk-related behavior, but on statistical correlations between predetermined criteria and personal data on either who you are, such as education level, age, occupation, when it comes to ETIAS and VIS, or your travel patterns when it comes to the PNR regime. And this reflects a shift from traditional deductive logic based on causality to inductive probabilistic reasoning based on statistical correlations. And I illustrate the difference with this table with this reindeer here. On one side, there is traditional legal decision making, and this involves so-called deductive reasoning based on logic of if this, then that. This kind of reasoning is based on causality and involves reasoning towards certain conclusions. In legal decision making, that basically means combining the facts at hand with the relevant legal norm and draw conclusions. This kind of reasoning is based on certainty and causality, where the legitimacy of the decision comes from the causal link between the facts of the case and the legal rule and the explanation of the reasons for the decision. Instead, data-driven decision-making is based on so-called inductive reasoning, which is reasoning towards likely conclusions based on data. To illustrate the difference, let's use Rudolph the reindeer here in the picture as an example. The logic kind of goes like this. For deductive reasoning, you would say, all reindeers are mortal. Rudolph is a reindeer, so it's certain that Rudolph is mortal. The inductive reasoning would go more like this. Most reindeers are brown. Rudolph is a reindeer. Therefore, it's likely that Rudolph is brown. As the automated risk assessment illustrates, the decisive factor for this kind of process is the presence of a statistical correlation between the personal data and the predetermined criteria. And the legitimacy of this predictive reasoning comes from the statistical correlation. And it follows, in my view, that data-driven decision-making has a weaker connection to the rule of law. Whether these systems can reliably identify individuals who might reasonably be considered risk depends on the assumption that statistical correlations discovered through data mining accurately reflects real-world risks. And measures partly based on statistical correlations make it difficult for individuals to anticipate why the processing of their personal data will trigger a hit, as the logic underpinning these systems is inherently opaque. And I think that the Court of Justice requirement that the predetermined criteria target individuals who might be instead of are reasonably suspected underscores this tension. My final third point relates to how it is by default more difficult to ensure foreseeability for legislation governing automated risk assessments. While I developed this in detail in the draft I'm working on now, I won't have time to share this point with you in details today. However, in essence, it revolves around demonstrating how it is difficult to do business as usual when interpreting the foreseeability of laws when it comes to laws regulating automated risk assessments, because they come with very specific rule of law challenges in terms of how to delimit what I call the algorithmic discretion of written laws. The actual effect of such regulation is not only determined by the written legislation, but also, for example, the technical design of the screening algorithm and how the predetermined criteria is established. And this weakens the link between the legal rules and their application and ultimately reduce the foreseeability for individuals. And I illustrate this with two examples. The first example relates to how many limitations in legislation and case law are perhaps too generic to be meaningful. There are already several existing limitations on the establishment of predetermined criteria to be found in the Court of Justice case law and relevant legislation. For example, these criteria must be specific, proportionate, reliable, and non-discriminatory. But rather than functioning as concrete constraints, they more resemble end goals or outcomes to be achieved without specifying how these outcomes should be realized, that is to say, the actual exercise of power. These generic limitations reflect desirable qualities in the application of law. However, for laws on automated processing, these general limitations lack operational specificity and do not prescribe methods or procedures capable of ensuring the values that they represent. And this vagueness, combined with the technical complexity of embedding legal norms into algorithms and predetermined criteria, weakens the law's ability to limit discretion. In sum, enhancing foreseeability requires legislation that more precisely defines how predetermined criteria and algorithms may be established and function. And this could involve the EU legislator prescribing more specific methods for establishing such criteria rather than delegating this task to agencies, the Commission, or member states. And in addition, the Court of Justice could strive to offer more concrete guidance on the minimum standards required for the quality of laws regulating automated processing. However, this is a difficult task, as too much foreseeability in how an algorithm actually works risks making the whole procedure pointless, as it can be circumvented by those one is trying to target. The second example relates to foreseeability issues with the courts filling out what I called open-ended techno-regulation. As a well-established principle of interpretation, secondary EU legislation must be interpreted by the Court of Justice as far as possible in a manner that preserves their validity and ensures conformity with primary law. And this interpretive principle has specific implications for foreseeability requirements, especially in cases involving automated risk assessments in border control. For example, in the case Ligue des Droits, the Court of Justice upheld the validity of the PNR directive despite its imprecise wording in some provisions. The directive was deemed sufficiently clear and precise, but only after the Court of Justice clarified several of its provisions. Now, from a rule of law and foreseeability perspective, this raises some concerns. While this interpretive approach helps avoid invalidating EU legislation, it prompts the question, would it not be preferable in some cases, both foreseeability and institutional balance, for the legislator to be required to draft clear and specific laws from the beginning, rather than relying on the judiciary to fill in the gaps? These concerns are particularly relevant in the context of automated risk assessments, because provisions governing the establishment of automated risk assessments and their essential components are usually open-ended in that they often leave room for countless interpretations with countless technical implications influencing how the rights to privacy and data protection are limited. And their opacity makes it difficult for individuals or even courts to understand how this system operates or how they limit fundamental rights. If the Court of Justice were to interpret such provisions, it would be tasked with reducing a vast range of possible technological and legal outcomes to a single foreseeable interpretation. And one example of this is how the PNR judgment Ligue des Droits has sometimes been interpreted as a ban on using machine learning. However, this is easily bypassed, as the limitation made in the judgment, in my view, is very narrow, as the court only makes statements in relation to machine learning, which is capable of modifying without human intervention the assessment process and assessment criteria. And I would say most use of machine learning is not covered by that, as it's not reasonable nor practical that any actor would want to use self-learning techniques without a human checking the result before deployment. So the court statement does, in my view, not prohibit using machine learning as long as a human checked the result before employment, which is common practice. And this satisfied the formal requirement of human involvement, yet fails to address the underlying concern. These were the 3 points on foreseeability that I wanted to share today. To finally summarize my presentation, I would like to leave you with the question: if unforeseeability just might be an inherent consequence of implementing automated risk assessments in border control. The logic is that for automated risk assessments to be efficient, the technology and the manner of establishment of criteria must be unforeseeable to a certain extent. Otherwise, the individuals targeted to be detected may circumvent the system. And this system rely on maintaining a certain level of opacity, which leads to perhaps an unsurprising conclusion. If one wants to implement systems built on risk criteria one does not want to grant access to, which will be applied by a technical system whose design is secret, it is consequently difficult to comply with quality of law requirements. One could discuss then if courts should accept the application of these kind of systems based on a logic of a less strict version of legality and foreseeability, supported by jurisprudence that attributes weight to pressing general objectives of security and border control in the balancing of what is the proportional limitation of rights. Or perhaps courts should resist lowering foreseeability standards, particularly in light of the legality challenges posed by automation. Echoing Judge Pinto de Albuquerque's separate opinion in Big Brother Watch, perhaps the judiciary should demand stricter safeguards to defend the rule of law when new technology leads to increased risk of abuse. This might warrant stronger and not weaker safeguards, at least if one does not accept that what is useful should be permissible. So now we're back at the turtle with the sail and the motto, hurry up, but do it slowly. Automation is certainly not negative per se, and fully human decision-making definitely has its own challenges. However, the current automated risk assessments approach to border control is new, and it rests on a different logic compared to traditional human decision-making. In a liberal democracy based on the rule of law, there are well-established, democratically enacted legal structures to deal with flaws in human decision-making. But similar structures remain to be established when it comes to laws regulating the use of algorithms, which rely on statistical correlation and probability over certainty and causality. These structures and rule of law safeguards must be put in place, and they will be different from the ones we have used in a non-automated context. And the sailing turtle motto of hurry up, but do it slowly illustrates the idea of that it's better being safe than bold in a rule of law context. And I want to close up with sharing my concern that it's important that the compliance with the rule of law is ensured before implementing unprecedented automated systems. And I guess that's my final point, that when it comes to the automated EU border control, maybe the rule of law requires a bit more turtle and a little less sail. Thank you for listening.
Thank you, Amanda, for your presentation. You made perfectly clear that data-driven decision-making based on probability and not on statistical correlation and not on certainty puts rule of law on the edge and offer a wide margin of discretion to law enforcement officers. So it's particularly interesting that you highlight at the end the importance to put the rule of law principle at the beginning, like rule of law principle by design should be the method to apprehend all these tools and all the law in order to regulate these tools. And it seems that it's not particularly the case at the moment. Here we are going to listen to Chris Jones, Director of Statewatch. Statewatch is really important for all the academics present here, helping us to understand how states in the European Union are watching upon our shoulders and looking at us at every moment and restraining our rights and liberties. So it's very important to benefit from the insight of Chris. So thank you, Chris, and the floor is yours.
Hello, thank you for having me. Thank you for the invite. As Marie-Laure said, my name is Chris Jones. I'm the director of Statewatch. And very briefly, Statewatch is an organisation, charitable organisation that exists to produce and promote investigative journalism and critical research and policy analysis on issues to do with civil liberties, human rights, and democratic standards. Europe and our niche is in primarily in EU affairs, and as perhaps you know, we've done a lot of work on European Union border immigration and asylum policies over the years. I should also say that Marie-Laure is one of the wonderful members of our board of trustees, in the interest of full transparency. So yes, thank you for having me. I feel incredibly underqualified in a virtual room full of academics. I also think some of the things I was going to say have already been said, so hopefully I don't, number one, repeat myself, and number two, tell you all things you already know. But I suppose what I'm going to do a bit is maybe zoom out slightly from some of the interventions we just had. Maybe that's why I've been invited. I suppose I'm bringing history and politics to the legal analysis. Or I'm trying
That's right.
to. Okay, well, let's see how it goes. So, as I'm sure you all know, over the last 3 decades, the EU and its member states have built a very extensive infrastructure of surveillance systems and databases, biometric identification techniques and information networks in the name of border security, immigration control, asylum policy, and so on. And I think it's interesting to look at the history of that a little bit, because that's important for thinking about what we can call path dependencies and what policy choices or actions are more or less likely in the future. Because the decisions that were made 20 years ago still constrain or influence the way decisions are made now. And also, I think we should bear in mind, I mean, what's the purpose of all this? From our perspective, the ultimate aim is really to provide state authorities and EU authorities with knowledge of and therefore control over foreign nationals who are seeking to enter or stay in the EU. And that's whether they do so by authorized or unauthorized journeys. In either case, it has implications for people's rights. If you are allowed and able to enter the European Union in a authorized or regular manner, you're going to be subject to privacy invasions. That's especially with the travel authorization system coming in, or if you're subject to a visa, or if you've got to have your fingerprints place stored in the entry-exit system. And the more extreme ends, the worst effect of these measures is death or extreme maltreatment. So think, for example, about the way that drone surveillance is used to have people pulled back to Libya by Libyan Coast Guard. So you have this digital infrastructure at both ends of the mobility spectrum, let's say. And yeah, what does it really consist of? Well, as Evelyn said, we have a lot of large-scale biometric databases, and obviously these have been extended somewhat in recent years. We've got new databases still under construction. The entry-exit system next month, I think Germany and Portugal I've seen so far are going to start using it, and then we'll have this staggered introduction. So next time I visit the European Union, I look forward to being fingerprinted and photographed. Can't wait. I'm sure everyone's going to feel much more safe. And then, of course, there's the fact that systems like the Schengen Information System, the Visa Information System, the Entry-Exit System are being joined up or made interoperable, as the EU likes to say. Through that, we have, other large databases being developed, in particular this Common Identity Repository, a huge centralized biometric identity database, which will store the identity data, all these separate systems, and that will be then made available for searches by the police and immigration authorities. And no doubt, I think in the future, we will see some new uses or ways being found to process that information, as these things come into use and sort of become part of the furniture within this architecture. Obviously, to go with biometric databases, we have biometric documents. 2004, EU citizens rules for EU citizens to have biometric passports were introduced. 2008, we got biometric residence permits for foreign nationals, and also an obligation on foreign states that if you get a visa waiver to enter for your citizens to enter the EU, you can only have that if you issue biometric passports to your citizens. Then in 2019, I think it's still being discussed. We had biometric identity card legislation that said if you're an EU member state and you issue identity cards, they need to include fingerprints and a photograph. I think for some maybe tedious legal reason, it's going through the institutions again, but it doesn't really change the law. It's just the legal basis, if I remember rightly. So we see how these things they don't just affect foreign nationals. The same techniques and technologies are also applied to citizens. So to greater or less degrees, everyone gets caught up in this web one way or another. Then there's what we have, surveillance and data infrastructure. So this again goes back at least 20 years. 2004, we have rules on advanced passenger information. That's basically the information in your passport getting sent to the police before you make a journey into Europe. 2008, the European border surveillance system starts being developed, although we don't get legislation until 2011, in a nice tribute to the rule of law. 2013 onwards, we have things called readmission case management systems. These allow the exchange of data between European states and states which they want to deport foreign nationals. And throughout this period as well, we get many of the the research projects that have been mentioned, Avatar, iBorder Control, all these slightly sci-fi, Hollywood dystopian-esque technology adventures. The Passenger Name Record Directive has been mentioned. Then there's been various scandals about the European Asylum Support Office, as it was then called, or Frontex monitoring social media platforms. Europol obviously also does that, particularly in the name of countering migrant smuggling. And then also slow export of some of this infrastructure or elements of it to non-EU states. Obviously, all the states in the Balkans that are supposed to accede to the EU, their IT systems and their legislation has to line up with European stuff, but also Frontex exporting risk analysis cells and this risk analysis methodology that applies to European borders to places like Niger and various other locations. So it's a very expansive sort of set of institutions and ideas that is still very much on the march, I would say. The broad shape of it has taken a long time to emerge, and no doubt it's going to change more in the future. But we're in a sort of consolidation in Europe and an expansion abroad phase, I would say. All this is done using lots and lots of public money. There were huge increases in the EU budgets between 2014 and 2020, and then 2021 and 27, which is where we are now. The Fund for External Borders increased in size by 130%, for asylum, migration, and integration by 43%, for internal security by 90%, and the Commission's very ambitious proposals for the next budget have even bigger increases. So the internal security funds, the proposed increase for that is 260%, from about 2 billion to almost 7 billion. The Borders Fund is supposed to, or the Commission would like it to increase by almost 150%, which would bring it up to more than 15 billion euros. And then oddly, well, maybe not so oddly, because I think they care more about border security than migrant integration, the Asylum, Migration and Integration Fund is supposed to increase by about 21% to about 12 billion euros. Then there's going to be a couple of billion for security research projects, so more stuff on drones and information mining and surveillance technology and predictive analytics and whatever else there is. And there's also the aid and development budget, which there's been a big push to use that for migration-related projects in foreign states. That's currently about 80 billion euros. The Commission wants it to be 200 billion euros altogether, although that is merging, I think, a couple of instruments. But still, you can see the level of ambition. I mean, the resulting budgets aren't going to be that large, but I think a fairly substantial increase is probably likely, especially given every policy statement or paper that has come out about this, discussion papers you see in the council, huge emphasis on the importance of immigration control, securing borders, so on and so on, all these things that they've been trying to do for years, which don't really ever work, just seem to make things worse. Maybe it's worth touching as well on, I think again, Evelyn, you sort of spoke about this, you mentioned Europol and Frontex's industry days, and I think they're really a symptom of something that has been very deliberately constructed over the last 20, 25 years, which is, for shorthand, you can call it the security industrial complex. The industry is seen as the people who have the technological solutions, as they like to say, to the problems that the public sector has. They're supposed to be the people who set the requirements for these companies to develop solutions. It's always been a problem between, companies coming along and saying, we've invented this new gadget, and, the police or a border agency then saying, well, we didn't ask for that and we don't think it's very useful. So particularly over the last 10 or 15 years, there's been a very long, slow, expensive and intensive process of trying to increase tighten the links between the public and the private sectors, whether that be through specific research projects or specific types of contracting or certain requirements, for authorities to purchase something for testing or whatever it might be. But you can see the public and the private sectors becoming increasingly intertwined, which raises obviously a lot of questions about political influence, the democratic process. Certainly there's been a few corruption scandals buried in there at certain points, and so on and so on. And I think you can see this in a very sort of day-to-day structural sense in EU LISA, the database agency, where it's actually private contractors that are primarily responsible for designing and maintaining these huge immigration and policing databases. There was a report in Bloomberg a while ago, which sort of talked about some leaked data protection audits from within EU LISA, or which were done of EU LISA. Not very flattering. The supposedly efficient lean private companies that are paid to do this stuff are not doing such a good job, which is rather alarming. So there's some questions about that. How suitable is it to have hundreds of millions of people's sensitive personal data being managed by outsourced contractors? Is this desirable? Some might say it's not desirable to collect that data in the first place, but even if it is, who should look after it and how? It's always a good question to ask. So, yeah, with all that in mind, I mean, you might say, well, so what? That's just what happens. This all seems to happen everywhere. And yeah, I think the longer you spend researching these topics and following them, the more normalized it becomes. I think it's important to try not to normalize them, and actually historicizing them is one way to do that. You can say, well, it didn't used to be like this. Why is it like this now? And why does it have to be this way and not another? I think for that, it's also interesting not to see the EU in isolation. There is, we'll have some research out about this in a couple of months, but there is really, this is the global project. I mean, I mentioned the whole biometric passport, biometric passports. that was actually something that went through the UN and then to the International Civil Aviation Agency, the International Civil Aviation Organization, rather. So, and there's various other projects and initiatives and Security Council resolutions that mandate things like biometric border databases, things like PNR systems, predictive profiling. So we should also bear in mind, as much as the EU tries to export its standards and ideas to other countries, there's also the question of to what extent global institutions, are playing their part in maybe not setting the EU standards, because often the EU does these things first, but yeah, the extent to which is part of a bigger picture. I think that's a topic for another time. Like I said, we have some work coming out in a couple of months about that. I'd say another, I think, important issue that to think about now is the way that the digitalization of borders and border controls isn't just targeted at external border controls, but let's say the whole migration chain. And there's a big focus at the minute. Right, before I get to that, I would say, yeah, it's not just about the border, but it's more perhaps about how the border becomes wherever a foreign national is. That's one of the things that digital technologies allow, right? You can move the border, you effectively attach it to an individual's. I mean, in the case of things like facial recognition and remote biometric recognition, you can actually literally attach it to someone's body if you have the infrastructure to detect and identify them wherever they go. But I mean, here, in the UK, we have some, I think, good examples of that. Is the government outsourced immigration checks to people like landlords, to banks, and they said, those businesses actually have access to the Home Office immigration register. They can scan someone's passport and they'll be told you can't rent to this person because they don't have the right papers. This has various knock-on effects. Some studies were done a few years ago. That meant that landlords were also just saying to black and brown people who are British citizens, they'd be putting them off in certain ways because they didn't want to have to get into checking their papers, or they assumed that because they were black or brown, they weren't citizens and they wouldn't have the right papers. That's a bit of a diversion. Sorry. The point was that, we have this emphasis at the minute on other parts of like the migration chain. There's obviously a huge policy push around deportations or returns, as they euphemistically like to call it. There's, the digitization of national systems, connecting them all up to Frontex, trying to have uniform control, uniform systems and data architectures to sort of smoothen the whole process. Lots of the changes to EU database rules were actually about making it possible to use the data in them for the purpose of returning people to foreign countries. Obviously, there's other issues with that in that countries don't often want to accept their own nationals, but that's why we're now getting the changes to the rules on safe third countries and the removal of various safeguards and protections in the proposed changes to the return directive. And this is really a form of deregulation, which is, as I'm sure many of you will know, is happening in other spheres. There's been this big push to, cut red tape and so on. What our friends in the environmental movement, for example, will say, well, that's really just letting polluters get off the hook. I think a particularly interesting thing for this discussion, I don't think it's come up yet, is that the AI Act is one of the pieces of legislation that's in the crosshairs for this deregulation discussion. I think initially the Commission said they wouldn't, they're going to continue with implementing the AI Act. Now Mario Draghi has come out and said, no, we've got a pause. I don't know who elected Mario Draghi, but he just seems to hang around powerful institutions, and his opinion has some weight. So now it's in the Commission's call for evidence on this simplification agenda. It doesn't give any detail on what they want to do with the AI Act, but you can assume it means not implementing certain parts of it. And even though, but on our view, the safeguards in it are extremely weak in many cases or non-existent, better to have what's in there than not have it at all, I think. I think maybe it's worth going, one of the, just briefly as well, going into that a little bit. like the AI Act is, I think, in relation to immigration and borders and policing, a very weak piece of legislation, or a very permissive piece of legislation, if you want to see it from a different angle. For this discussion in particular, there's one particular provision that says the Act only applies to affected persons that are located in the Union. So that basically means, assuming they apply the parts of the Act to the EU's large-scale databases to travel authorizations and visas, if you're outside the EU and you're applying for a travel authorization and computer says no, you don't have any right to remedies under the Act. You might have remedies under data protection law. I think that's maybe something interesting for the discussion, like where, if anywhere, will people get those remedies from? And if the AI Act is not meant to supersede data protection law somehow, why apply that geographic limitation to it? Yeah, I did have a. I think, yeah. Then also, just in terms of, you know, maybe just to finish up, we have this infrastructure that has been built over these decades, and I think aside from sort of, you know, getting these databases into action, you know, digitizing member states' return management systems and so on, it's interesting to think about, well, what then would all this data and these tools and these systems be used for? What could they be used for? There's obviously an awful lot of hype about so-called artificial intelligence and how and where it might be used. There's been some very interesting studies on this published by the European Commission in the last few years. And by no means are the views in those going to become policy, but I think it gives you, to read them gives you an interesting idea of where Interior Ministry officials, for example, think that AI could or should be used. So as studies that have included, you know, use cases based on interviews with state officials and the EU officials, to go back to precisely a point that was discussed earlier, one of the use cases is using cameras at border crossing points to detect people or vehicles of interest and flag alerts in the Schengen information system, AI systems to flag risks during like border interviews, using AI to detect irregular traveling patterns. I mean, it's kind of already done with the PNR systems, but more of that. Particularly disturbing, what I found was using AI to assess a person's success in integration by apparently in contact with the immigrant, which is a quote, alongside data from external sources like tax statements. So a computer would somehow, for some unknown reason, judge the extent to which you had integrated into European society. AI to perform, to detect, to do vulnerability assessments for asylum applicants, and to predict the risk of applicants absconding, and to decide what detention centre people should be assigned to. So there is no guarantee any of these are going to become law or policy or practice, but these are the things that government officials have in mind when they're asked about what could we or should we try to do with AI. So there's a lot to deal with now. There's probably likely going to be a lot more to deal with in the future. And for that reason, I think it's good we have people with brains such as yours able to dissect this stuff. I suppose the broader question is, that's very good, but what in practice are we going to do about it? Which is a political question, which maybe goes beyond our discussion here, but I'll leave it there. Thank you.
Thank you so much, Chris. I wanted you in this panel in order to give some flesh and some blood to the legal issues the others were presented, because talking about digitalization of border control, talking about artificial intelligence, it is also public money. And you made it clear that the funding of such tools is increasingly exponentially. So it was important to say that. It was also important for me that you insist on what you call the symptom of something deliberately constructed for years. And we have a path dependency of with our trust in technology to solve it all. and to solve it, our immigration problem that is in fact a social, political, legal construction of our society. And I think it was very important to see that it is a continuum with an expansion and explosion of all these devices that are automated mechanism to take some decisions regarding migrants and refugees. But I'm just going to give the floor to Niovi that is there, but she has some technology issue. Maybe she will need to switch off the camera, but thank you for listening to her very carefully, because I'm sure she has some really important insights to give us about different presentation. Dear Niovi, the floor is yours.
Yes, first of all, thank you so much. I hope you can hear me well. I am outside office, so at some point I may have to close my camera. It's so nice to have this event. It's also so nice to hear from such lovely colleagues and practitioners from different perspectives. So I have some comments on each of the presentations, but I will raise also at the end some points which are of broader application. And I will start with the order of presentations. Thomas' presentation and paper, which I read with great interest. There are two things that, first of all, I wanted to highlight. The first one is has to do with the different case studies that Thomas presented, which demonstrated very clearly what has been mentioned for many, many years, that technologies that are being tested on citizens or non-citizens and then being also tested on citizens. Here we have also the reverse paradigm in a sense, because PNR actually has been implemented before ETIAS, and then yet we see the same logic of the PNR, very much a law enforcement logic, which has been ironically implemented to equally to mobile travelers, equally citizens and non-EU citizens, to the case of ETIAS, and a little bit differently, but with a very similar logic also in the case of the visa information system. So this kind of technology testing ground of new technologies in the sphere of mobility more broadly, we see it very prominently in this case. Another comment which I had, which has to do precisely with the issue of remedies in the case of ETIAS, and along with Alexander Karescu, we just have an article accepted precisely on judicial and extrajudicial remedies in ETIAS and VIS, and we notice very similar issues with those that Thomas mentioned in his presentation about the difficulty, the black box of, or the ticking box exercise of a negative ETIAS decision, whereby it will be very difficult for an individual to actually understand why an ETIAS application may have been rejected. There is indeed a form for a refused applicant, which is going to have a text box, which is going to be mandatory. So at least we have that. The text box will be mandatory. Authorities will have to say something, but it is very unclear what they will say and how that text box where the ETIAS national unit will have to explain why an application has been refused, what will be the reasoning, whether it will be something vague, something specific, something substantial that can help the individual understand and see whether there is a scope of contesting that negative decision. I see a potential in two ways. There are two things that we have noticed in our article, and I wanted to ask Thomas how he views them. One is a handbook that the Commission has to prepare, and if I'm not mistaken, it is prepared. It is not, however, publicly available, and how that handbook that is embedded and is envisaged in the ETIAS regulation can help in providing at least some consistency in the decision on a negative decision. And second, what is the role of the Fundamental Rights Guidance Board, which, if I'm not terribly mistaken, has been looking precisely on that matter, and how at this level there could be some kind of guidance as to what ETIAS national units can do on that front. With regard to Evelyn's presentation, and Evelyn and I have been doing for many, many years sister research, in hearing also her insights on facial recognition technology. And I notice that you mentioned quite a lot of the importance of the European Court of Human Rights case law going back to the past. And there I also noticed how Amanda was saying that, yes, the Court of Justice tried to keep up, but it's also not really living up to the expectations. And sometimes, so I see a very interesting thing where on some fronts, we have to go back to the basics, back to the really 50-year-old case law, which is still very much relevant. And on other fronts, the case law hasn't kept up, cannot even keep up in newer cases. So that's a very interesting thing that we already noticed. As regards the legislation, I have even more negative views about the AI Act, and I don't see it as a good opportunity on many fronts. But the problem doesn't start from the AI Act. The problem starts from the fact that biometric data basically have not been subject to definition in the GDPR that has, in my view, been protective enough. And the reason why this is the case, because if we go to Article 9, we will see that biometric data have a special status, a special category of personal data when they are used for identification. So within the GDPR, there is a distinction made between verification and identification. And that is wrong. And this is where the problem has started. It has started already from the GDPR. The AI Act continues a very problematic approach and creates even more difficulties. Is it? Yeah, I hope you can hear me. Creates even more fragmentation on that front because the problem lies in the fact that, as Evelyn mentioned, it distinguishes between remote, real-time remote biometric surveillance, the biometric identification as a high-risk AI system, biometric verification as posing a limited risk. So I noticed that you mentioned 4 different approaches, and I actually see 6 of them. So I also see biometric verification as a 5th approach. So when biometrics are used only for verification, and then they are not high risk, and they pose a limited risk, so they are subject to even less safeguards. And there is a 6th approach, which is even more problematic, and is the following. Article 6 of the AI Act allows the possibility for developers to self-assess AI systems as not posing a high risk and declassify them based on a self-assessment if certain conditions apply. So for instance, if there is a narrow procedural task, or if it's a preparatory task, and it doesn't really affect the decision-making. Therefore, there is a possibility that actually even biometric identification, if it is part of a broader assessment, and it's not itself material for decision-making, that actually can be declassified as not posing a high risk. And I think it's even very much problematic. And based on what Chris also said about the application of the AI Act to individuals within the European Union, we see additional problems with biometric identification, remote and real-time, in the high seas, so outside the European Union, based on Article 5 as an exception, without any protective safeguards of the AI Act. So I see a series of problems in biometric identification, basically use of biometrics for surveillance purposes, and all these approaches are very much problematic. So that differentiation doesn't really help at all. I noticed that you mentioned that we have the safeguard of the possibility of having a judicial or an independent administrative authority authorizing real-time biometric, remote biometric surveillance. I'm not happy with the administrative authority. I don't think that there is an administrative authority that can be independent enough that can have equal safeguards as a judicial authority. So I'm not also happy with the application of Article 5 as an exception. And because it's an exception, it needs to also to be of limited application. And I fully agree with you, the way that Article 5 is drafted, it doesn't allow for limited application. Moving now to Amanda's presentation. I found fascinating. I always, when I see your presentation, you always do these parallels with some kind of, the Cinderella shoe. So I was really expecting and hoping to hear more about your perspective this time. And I noticed that I fully agree with you that we start having a real foreseeability problem. And the problem I see is not only one of how we design, how we don't know how the systems are designed, the algorithms are designed, but also we see a persistent problem at TU and national level of whether the algorithms qualify as AI or not. And I think that this is a big problem because we see it in the case of the UK, we see it in the case of the Netherlands. The authorities hide behind the term algorithm without explaining how this operates and whether does that qualify within the broad definition of the AI Act. So is this artificial intelligence within the scope of the AI Act or not? And I think this foreseeability problem is a fundamental one. And based on what you said about how much foreseeability we need, definitely there we need foreseeability. We need some foreseeability as to whether a system operates as an AI system or the algorithms are simpler. So there, because of the lack of we have opaqueness for many reasons, that opaqueness needs to stop. And we see that at national level, we see it with ETIAS, we see it with VIS, we see a persistent use of other terms aside artificial intelligence. We see responses that are contradictory, even from Frontex, and this needs to stop. Because we can discuss for hours the application of the AI Act, but in order to have the application for the AI Act, we need to know whether we're talking about AI. In any case, what we're talking about. So there, for that, we definitely need foreseeability. I also see that in the case, especially of ETIAS and VIS, especially of ETIAS, there is a problem of foreseeability stemming from the fact that we are hiding behind more than 50 non-legislative acts, and we consider these as delegated implementing acts as non-legislative, and these seem to fall behind, in between the cracks, as not falling within the foreseeability criterion because these are non-legislative acts. I do not agree with that approach. I think that there is a lot of juice in them. These non-legislative acts may have very much important elements with significant implications and therefore need to also fall within the foreseeability requirement and need to be within whether to see whether something is in accordance with law. And the mere existence of so many acts is a rule of law problem, is a foreseeability problem. It creates lack of foreseeability because, first of all, they are not always public. Even if they become public after many efforts, they still are too much and too technical on some fronts to be able to evaluate, and therefore not even the reader who is informed can fully analyze and understand what they need. So these are, at least for me, a minimum foreseeability, because you said how much foreseeability. The courts have never talked about full foreseeability, even in earlier case law that we were looking at, as Evelin was mentioning. There needs to be, of course, a degree of foreseeability, and I agree that we are not even fulfilling that degree of foreseeability on many fronts. So definitely there is much more to wait and to expect here. As regards Chris' presentation, which was a little, I couldn't hear everything, Chris. I'm really sorry about that, but I did hear some very interesting points that you made, and I really like the fact that you try to provide, an overview of what exists. And I think you need to praise StateWatch a bit more because through your documentation, I found out that there are more than 40 projects in the last decade or so which have a relevance to migration. And there are research projects, more than 40, which have a relevance for us on technology in the field of migration. And we see constantly one project after the other, building on one the other. And now, for instance, in the reaction one, we are reaching the final stage with a full implementation on national level based on previous work from Rob Border, etc. So I think that this is, we are reaching now a point where technologies are not just research projects, but actually become reality on many fronts. I do see the role of EU LISA particularly problematic. It remains with this mandate a technical agency. The data protection unit cannot do much. There are like 10 people over there and cannot oversee everything. And I'm not sure that they are taken, seriously with their concerns that they are making. And in any case, the data protection unit, it's not a unit of fundamental rights more broadly. And AI or all these systems are not just about data protection. We cannot downgrade and not downgrade, limit the impact only as a data protection problem. And finally, you mentioned quite a lot about the importance of the industry and of private actors. And I think that going back to Amanda's work, the role of private entities, and it's also part of foreseeability. We need to know who is contracted. We need to know how they are working, what information they have, whether they are using real data. So are there people who are engineers contracted in a private entity that have access to the database in order to create the algorithm? This is information that we need to know as as EU taxpayers, as potential targets of new surveillance systems in the future. So that is definitely something that we need to know. I think I will stop here. I did have quite a number of other comments that I could mention, but I will stop in order to give a little bit time for questions from the audience as well. So thank you so much.
Thank you, dear Niovi, for all your inputs. I think that I'm going to give the opportunity to our interveners to have the floor in order to react to your elements, to your inputs. I propose we follow the order we have during this workshop. So Tamas, the floor is yours for a few minutes, and all the others we have also some minutes to react to Niovi's comment. And afterwards, we will give the floor to the audience, even though we will have some minutes offered to Elspeth Guild to ask some questions to all the interveners also. So Tamas, the floor is yours. Oh, it seems that Tamas.
Yes, I started speaking by being muted. After 5 years of COVID, it's still an issue for me. Shame on me. Anyways, now I hope you can still, you can now hear me well. So thanks a lot, Marie-Laure, for giving me the floor. And another big thanks goes to Niovi for the vintage, thoughtful, insightful, and very, very, how to say, horizon broadening inputs and comments. I mean, I would like to focus on, let's say, those points. Maybe it's one or two where a question has been raised. Otherwise, I mean, I fully share what she has just said about the PNR as the testing ground for, mobility. I mean, for AI-driven technologies used for in the context of mobility for checking and surveying third country nationals. Indeed, I mean, I share the concern that even if now in this 2022 Commission implementing decision, which is like a very low level of, legislation, sort of a bylaw with all the general issues connected to non-fully fledged co-legislator adopted pieces of EU law, that, I mean, this Commission implementing legislation at least foresees this free text let's say, rubric to include an explanation of the facts and the law which led the authority to refuse a travel authorization. And it remains to be seen what will be explained there actually. I mean, it's good that it's mandatory, but I also have my concerns how administrative convenience can just, reduce it to the bare minimum. And what has come to my mind is that in case of the good old traditional refusal of entry forms, which is another annex, this time an annex to the Schengen Borders Code, a similar logic applies. You have let's say, a ticking box exercise. You can, as the border officer, tick a box when it comes to the given reason why you just refuse the entry of the third country national in front of you. And then you can also add some explanation. In most of the cases, this is just a tick box exercise for those who have been refused entry under the Schengen Borders Code, Article 14. And I mean, I've seen quite a number of those refusal of entry forms in practice when I joined various Schengen evaluation on-site missions in many member states. And I mean, what information border guards provide in those forms, it's just, it converges to the bare minimum. And of course, these negative decisions, the refusal of entries, are then subject to judicial review. They can be appealed. But I don't know, I'm not aware of any research which would have had this empirical component of, I don't know, looking into actual actual cases appealing refusals of entry, and what was the information provided in the original form, and how the court reviewing this very skeleton explanation or just tick box exercise raised issues or even cancelled or annulled the refusal of entry because of lack of information, lack of reasoning. So all these issues which just empty the actual exercise of this right. So I can draw some parallels here, and although refusal of entry forms are with us for, I don't know, 20-something years, since the Schengen Borders Code goes back to quite some time. We still don't know exactly how that kind of information, that kind of, let's say, schematized decision making led to the breach of the right and effective remedy as pronounced by some national courts reviewing those forms. So the same applies to those future refusal of ETIAS travel authorizations, and this is just a call for the academic and research community to keep an eye on that, and once ETIAS will be up and running, I think that would be of crucial importance to see what is actually written in those bloody forms, and to what extent it will trigger judicial review, and how the courts will respond to that in the context of the review. And the other question was about the Fundamental Rights Guidance Board. It's a very spot on, let's say, question. As far as I know, they have quite, let's say, in a quite sophisticated manner dealt with the question of the exercise of the right and effective remedy against negative ETIAS decisions. This March, they issued a guidance note, which is publicly available, on giving information to refused applicants in order to give effect to the right to an effective remedy. So this is quite a lengthy document, but I find it quite useful. It really goes into the details. So when it comes to public documents, this is perhaps the best out there as of now. So I don't want to go into the details how it frames it, but it's quite useful. It breaks down the whole decision-making process in different steps, and gives guidance on how to make this right a reality for the affected people. But then, of course, it has limitations. So the Fundamental Rights Guidance Board is a guidance board. So it just it gives guidance to the screening board, which is the entity more in charge of the implementation of this new ETIAS system. And of course, this guidance doesn't have any binding force. This is just, I mean, if I want to be cynical, it's just wishful thinking. If I want to put on my more optimistic hat, driven by common sense and the lack of other authoritative, let's say, guidelines, this guidance note should be taken into account and taken seriously by the screening board, and also by national ETIAS units to make this right exercisable, if such a word in English exists. So I see that as a positive step, but again, Perhaps it's not enough yet, but it's at least a good sign that that has already been on the agenda of the Fundamental Rights Guidance Board, and that can be a springboard for further, thinking and elucidation and legal work on the matter. Over to you, Marie-Laure.
Thank you, Tamás. Dear Evelin, do you want to react to Niovi's comment?
Yes, thank you. And thank you, Niovi, for your very useful comments. I want to give a reaction to that first, and then also to a question of Elspeth on the privacy gap, which is now included in the AI Act. Niovi, yes, you're completely right. It starts with the GDPR. That is the missing part in this presentation. And I think the exceptions included in the GDPR, I would also refer to the Law Enforcement Directive, which also provides many leeways for national authorities, legislators, to use biometrics and personal data. So yes, that's completely right. It starts from there, and the AI Act goes on with that. And thank you for the two new categories. I will definitely look into that the problematic categorization of remote biometric identification is more. I will look into the provisions you refer to. I share with you the problem that the access to independent or the requirement of independent supervisory mechanism is not sufficient and not equal to individual judicial authorities, and therefore I stress case law by the Court of Human Rights that there should be in first place judicial access if necessary, or oversight by judicial mechanism. On the other hand, there is also important case law, and I now just focus on the European Court of Human Rights. For example, Sikkerstadt Wieberg, where it was about data collection, that the court, even if the national law provides for administrative overview mechanism, the court did consider, but does that then include independent overview? Like, has this authority, like it was about parliamentary ombudsman in this case, what authority has it to offer binding decisions? So sometimes, but I agree with you, I don't know many examples, but I would not, if you can say, well, those independent administrative authorities should offer the same independent and binding mechanism as a judicial court, then I think it could be okay. And then I also agree your concern and also the concern by Chris Jones, thank you for that, for noting the provision on the scope of the AI Act, only for persons inside the EU territory. That is, of course, very problematic. As we know, all those technologies and the other technologies you mentioned, Chris, are especially used outside the EU and at the EU borders. That's a bit, problematic zone. On the other hand, I think that maybe the feasibility, the applicability of this provision might be problematized by courts, but also by existing other laws like the fundamental rights non-refoulement principle, but also Article 47 of the Charter Thomas referred to, because, and also in addition to your contribution, Thomas, it is very important that exactly in Ligue des droits humains, where the Court of Justice assessed automated risk assessment and the impact for fundamental rights and emphasizing the right to effective judicial protection, the court referred to former case law on visa applications. Visa applicants are outside the EU, but they fall within the scope of the Charter because they apply for decisions. And of course, we have some discomforting judgments on the extraditional application of human rights, but I think there's an end to it. If you put people really within the scope, using facial recognition and deciding on those people whether they can enter or not. So I would really push on saying, well, those extraditional provisions, or there's an end to it, because And then we're going back, and then I'm coming to the question of Elspeth. The recital of the AI Act still emphasizes the use, the private life and fundamental rights of people affected by AI, developed and deployed by EU institutions, EU national member states, etc. So there I would say, the legislator, the EU institutions should be kept to their own promises. I don't say it how to say it in English. So the privacy gap, Elspeth, would be my answer, could be filled by saying, well, if you're now implementing the AI Act, whether by the Commission delegated acts or while developing new tools, you should deliver, and you should make sure that from the start, your promises on protecting fundamental rights, freedom of expression, non-refoulement, which is all in the recitals, privacy, make sure that it is from the start. And Marie-Laure, you also say it, privacy, but also human rights. And as Amanda said, rule of law by design, it is where it starts. So yeah, we should use the tool and fill in the gaps the tool unfortunately also has. Going back to, but what did you promise the citizens? Oh yeah, that is my final comment. What you also said, Chris, this normalization of extended tools, that's also what we should prevent. And that's why I'm now trying to write about facial recognition technologies, because we know in certain countries, like in China, people get used, and the use of this very invasive facial recognition tools are accepted or seem to be accepted. And you are right, it's not only about third country nationals. If we're talking about facial recognition tools, and the PNR and Niovi also mentioned that, it already affects EU citizens. And that's a bit my hope, that when the case law is starting from the EU citizens, we get, like in the PNR directive, we will get some better, stronger safeguards for third country nationals as well. Thank you.
Thank you, dear Evelyn. Amanda, maybe some words and maybe some remarks relatively to the point Didier Bigot made in the chat.
Yeah, absolutely. First, to react to Niovi's reflections. Thank you very much for the reflections. I completely agree with you about everything that you raised, especially in connection to the point with the private actors and the transparency of what they're doing and what their role is. I've requested so many tenders from EU LISA to try to kind of backtrack and see like who is doing what were they asked to do, what parts of the system, and it's really hard to try to decipher what is really going on there. And this also connects to the question, like, what kind of algorithm are they developing? I mean, that's a dead end there to try to ask any agency about that, which connects to your point about that the question if something is machine learning, rule-based algorithms, and if it falls under the definition of the AI Act or not. I mean, that's also still a mystery, and of course, a huge foreseeability issue. Then your point about non-legislative acts, that like some have argued like that this doesn't fall within the foreseeability requirement, because that should only consider like laws, and non-legislative acts are not laws. I also completely agree with you there. I would even take it a step further and say that like when you consider the second quality of law requirement of accessibility of law, I would say that maybe even the predetermined criteria that are not even established like non-legislative acts, but from EU agencies, and I don't even know how to define what kind of act that would be, they are also not accessible. And then the question is, do they also fall within accessibility of law, even if they are not laws, because they really determine the effect of the application of the power? And then a bit in response to this discussion of legal remedies and Tamas' presentation, these tick box explanations and check boxes. Since I'm very focused on this kind of automated filtering process, I've been trying to imagine myself like that. I really doubt that these legal remedies stemming from this will, like that the national authorities will be able to provide any clarity on the automated parts of the procedure, which is basically run by EU agencies. And I doubt that they will provide clarity on the actual filtering that led up to one being subjected to potential refusal decisions. And that when you challenge these kind of refusal decisions in the national member state systems, can you meaningfully also challenge the lawfulness of the automated risk assessment preceding the actual human decision making by the states? And to reply to the question from Professor Bigo about if I consider this binary divide between kind of traditional decision making, algorithmic decision making, if it's absolute or if it's more like a temporal political transformation linked with statistics, algorithms, suspicion prediction, or a combination of these, I would say that so far I found it useful to divide it binary in this way to really underline the connection between the reasoning of a law and the measure and how it's legitimized, like both traditionally and in measures involving algorithms. And perhaps this divide has been useful because this project I'm in now have a rule of law focus where the connection between the rule and the reasoning becomes very important. And I can also definitely see the point, depending on the lens one is using, to divide this differently, or that it actually explains this shift from causation to correlation, because it kind of goes hand in hand, that perhaps this shift is a form of explanation why we seem to be ending up here, to see this shift in legal reasoning and the political transformation actually linked with this. I believe that they go hand in hand. It's just a way of how I choose to phrase things with a rule of law focus. Okay, thank you.
Thank you, Amanda. I think that Didier Bigot wanted to highlight that there is a continuum, and in fact, you have to give a more in-depth analysis of the historical roots of such an evolution, and maybe you can find in those roots some element that can give you some rights on some modes of discretion of law enforcement that have been increased and deepened by automated decision making.
Absolutely.
And Chris, last words for you, maybe, in order to answer and to react to Niovi's insights.
Yeah, sorry about my sound. I didn't realize that was not working properly. I hope you can hear me better if I hold this little microphone here. Just in response to Niovi, I would just say, also I know we're over time, the point about data protection, yes, no, but obviously many more issues come up with this topic than simply data protection. All kinds of rights and touched on by AI systems, depending on how they're used. I think, we shouldn't lose sight of that, but I do think it's important or useful to think about the data protection question, because that's basically what gets offered to people as the compensation for having these these large information systems gathering data on millions of people. EU institutions will say, well, we're going to do this, but we've got a very strong data protection regime, and we know how to take care of people's information and so on and so on. When it's also a well-known fact that data protection authorities don't have enough money, people, or resources to do their jobs properly. So, I think our analysis has to go much broader than simply data protection, but a focus on that is also useful to highlight what's basically the hypocrisy of people saying, of course we can do this because we've got great data protection laws and enforcement, when that's not necessarily true. I think there's also an interesting point, maybe it's slightly snide, about how many implementing acts and whatever else we see. I mean, you can just look at the size of something like the AI Act. I mean, who is it supposed to be foreseeable for? What ordinary person, as I've read it several times, as I'm sure many people in here have, what normal person has any time to sit down and understand what all of that means? What did the Roman historian Tacitus say? Corrupt republics have many laws, which, I don't know, maybe it's worth thinking about. Finally, there was a question from Elspeth. The UK has a poor track record on the use of AI. Yes, the post office fiasco wasn't even AI, it was just crap software, which they couldn't admit was wrong. Is there public support for AI? I don't think I'm qualified to answer that, but we're about to get a lot more of it. In case you don't know, Trump is currently down the road from me somewhere with the government, and he's got all his mates from Microsoft and Google with him, promising we're going to get loads of data centers. So lucky us, we're going to get to be a US AI outpost. The nation is thrilled, I'm sure. And finally, so there's a point from Paolo. I don't know if it's for me, but it's about the UK. I am almost certain, Paolo, that yes, people who are facing prosecution for saying they support Palestine action or for taking action as part of that group, or many people, their names will end up in European databases, or particularly Europol's databases. British police officers say that since Brexit, operational cooperation is basically the same as it was prior to Brexit, at least in the most recent testimonies I've seen. It's just that the UK doesn't get a say in decision making. So we're still sharing loads of data with Europol, and that will almost certainly include information on people arrested for engaging in protest and civil disobedience. So where and how that ends up in, Europol's databases, or then in the Schengen information system, and then in national databases, yeah, there's a whole load of questions about that.
Thank you, Chris. Maybe I can give the floor to Tamas in order for him to answer the questions that have been asked in the chat. Maybe it would be easier for the listeners to listen to your voice than read to your text. So the floor is yours.
Yes, thanks, Alex Marie-Laure. I just started typing my written reflections regarding Elspeth. Super interesting and spot-on questions. I would start with the easiest one, the time limits regarding the manual review in case of a hit when something has been flagged by the screening rules. So initially, the time limits for the manual review, the first one is 4 days, so 96 hours. And if more information is needed, because the case is a bit more complex, then it can be extended up to 14 days. And even if a personal interview with the applicant is required, it can go up to 30 days. So it can be quite some time, and that's why, I just checked again on the official, let's say, Q&A put by the Commission on the internet. It even advises future applicants, to submit it well in advance, since in case you are not refused, but you are flagged and manual review is needed, then in complex cases, it can take up to 30 days to sort it out and to have it, let's say, done. As regards, then the other question was about, and allow me to scroll up if the system is now not on my side, but if I understand correctly, whether the national authorities are ready or, let's say, are willing to accept this obligation to give substantive explanation, not just ticking the box, but actually using the free text box and to really set out the reasons in fact and in law. My position on that is that there's nothing new under the sun. Each and every public authority of all member states had to get used to that, since any kind of public decision making requires setting out the reasons in sufficient details, no matter in which area we are, no matter what tools or technologies support decision making. So I think it is just the bread and butter of the quality of decision making required under EU law as well. It's a general principle of EU law, right to good administration, and so forth. So I would say that there's no justification to disregard the traditional rule of law principle of well-reasoned decision making. And they may be reluctant, but I don't know. I haven't conducted any legal sociological, research to look into where they stand and whether they don't feel like really into that exercise. We'll see. It's a must, and it should be translated fully into practice for sure. And I think there was a third question as well, but for some reason now I've seen that my camera automatically stopped. Maybe it's a question of bandwidth. At least you can still hear me, and the whole WebEx system is now frozen. So I can't do anything. I hope that you can still hear me. And this is the only,
Yeah, we can
let's
hear
say,
you.
okay, this is my only channel to this highly interesting workshop. I feel like a bit a digital Robinson Crusoe now, that this is my only life path or sign towards you. So I leave it here. We are also running a bit behind the schedule. So I mean, I stop here before everything crumbles on my end.
Thank you so much, Tamas. I just want to switch off, close on our debates with thanking you, Tamas, Evelyn, Amanda, and Chris for your really interesting interventions that were very fruitful, fascinating, and I have to confess, really concerning about the situation of human rights when artificial intelligence is used in order to make decision and process regarding third country nationals, and we can add nationals also. I just want to thank also all the person that attend such a workshop, and I invite you to spread the idea that we will have another workshop on the 17th of October, and the topic will be the EU borders and their thickness, offering a multi-dimensional perspectives on this thickness, this depth, this width of European borders. Thank you, everybody, and thank you, of course, Niovi, for her precious insights, giving some inputs, some elements, some comments, observations on the 4 interventions. Thank you all.
Thanks a lot, Marie-Laure, for pulling